So now I'm going to introduce Preston Bryne. He's an English qualified structured finance lawyer, fellow of the Adam Smith Institute, and founder and former chief operating officer of Monix, makers of the first open source permission blockchain client in 2014. It's since involved in the Hyperledger Burrow blockchain client. Professionally, he advises law firms, corporate counsels, and the public sector on how to think, communicate about, and deal with cryptocurrency, blockchain, cryptography, and distributed systems. Please give a welcome to Preston Bryne.
Right, now unfortunately this thing they have a laser pointer with the slide clicker, so I'm just waiting for a cat to show up. That'd be a ton of fun. But anyway, good morning. My name is Preston. I'm a lawyer in England and Wales, and we're here to talk about international law and practice regarding cryptocurrency. Why are we saying international? I hear some of you saying there's no such thing as international law, there is no world government, we don't like the UN. So cryptocurrency and distributed systems, as we see them in the wild, tend to operate on a cross-border basis. So when we're talking about our compliance obligations and what the risks are in building businesses that use these systems, we really have to think about what the impact is going to be in several jurisdictions in many different places. So today we're going to, rather than drone on and be like, well, this is what the Bank Secrecy Act says, and go through it provision by provision, as I know lawyers are wont to do sometimes when they're trying to show off how much they know. We're going to walk through just general themes about how to be compliant, and also talk about some stories that we've seen. So we're going to look at case studies, individual instances where people have fallen foul of the law, and as a consequence, they're either being sued for several $billion at the moment or in jail. So that should be very entertaining. So just by way of background, Fortune magazine called me a loudmouth libertarian as insightful as he is obnoxious. And that is easily the proudest achievement. Thank you. So by way of background, I'm an English qualified structured finance lawyer, mortgage-backed securities, and government guaranteed debt for evil banks, that kind of thing. That's what I did for a living, and hopefully what I'll be doing for a living again very soon. I practiced law for 5 or 6 years. I then went and founded a company. We did the first open source permission blockchain design. We forked Ethereum, put some permissions architecture in the Genesis block, and said this is a way that you can use Solidity and smart contract language without actually breaking the law or issuing security. So I left the company last summer, and now I'm currently just doing a master's degree in common law, and I'll be sitting in the bar and hopefully dual admitted by the autumn. So the format, as I said, we're just going to go through property interests in Bitcoin and taxes, what it does in terms of the basis of financial transactions, and then security law considerations and ICOs, which I would imagine are a fairly hot topic. So just a quick warning, I'm not your lawyer. This isn't legal advice. If you need a lawyer, go get one. I can refer you to many very qualified lawyers. And if you're going to do something in this space, it is a minefield. There are more mines that you could run into than a British battlecruiser in the Skagerrak during the Battle of Jutland. So really, this is something where you need legal advice. So property rights, let's talk about that. What is a Bitcoin? There was this very funny joke article about someone who in Brooklyn apparently sold Chuck E. Cheese tokens as Bitcoins and apparently made $1 million. Unfortunately, or fortunately, depending on how you look at it, it's not true. But as we can see, with someone comes into Bitcoin, they're like, well, can I hold it? What do I do with it? Like, is it money? And it kind of confounds description. So you have to sit them down and say, no, there's this thing called the blockchain, and walk them through first principles. Early civilizations had no concept of zero, that kind of thing. So what it really is it's an unspent transaction output. For those of us who know it, it's basically someone has written a new entry on the blockchain, and they've said, I've signed it with my private key and your public key, which means that this unit of Bitcoin you now can unassign to somebody else with your private key and their public key. So it's basically just a right permission to this distributed system. And it's not a physical coin, no one gave it to you, it's just there because someone else sent it to you. So as we can see, this is the kind of discussion that you have to have from the start. But as a lawyer, when we look, here we go. This is an old Dilbert cartoon about servers rewritten to be about Bitcoin. Don't give me the condescending simple version. Early civilizations had no concept of zero. That's when you sit someone down. One day, there's this man. His name was Satoshi Nakamoto. And everyone's had that conversation. And when you have to sit a lawyer down and talk to them, they go, well, Bitcoin, it's clearly some kind of documentary intangible, right? And well, no, actually, let's sit down and talk about where this stuff actually comes from. So we have to ask, whenever we're talking about who owns something, what is the title? So what is it that we actually have? How did we get it? And from whom did we obtain it? So if we're talking about a Bitcoin, well, yeah, sure, we got the title from somebody else. Someone sent it to us. Well, what did they send us? Is it a contractual right of some kind? Is it a physical object? Like, did I take out a phone and give it to somebody? That has definite legal treatment. But what if I've just sent someone this unspent transaction output? Is there any, is it like a security? What is it? And the answer is we don't really quite know. So let's go back really to first principles and talk about what property means from a philosophical perspective. So we've got Rothbard and Hoppe, so talking about the discovery principle as a way that you can create property. So if you have something out in the wild, you can go and reduce it to physical possession. And if you do that, then maybe you own the thing. So that's kind of the basis. So if we go look at Bitcoin, potentially we could think of it philosophically as someone created this, they then published the source code, and then that source code generates this kind of funky digital commodity, which we haven't quite classified yet. And if you manage to either mine a block or maybe get your hands on it in some other way, it becomes yours. So philosophically, we can look at it from that perspective. Another concept is Nozick, and so he basically said it's the right to exercise the rights of an owner, and that's another common, that is passed over into the common law as something where, if you look at theft, for example, if you exercise the rights of an owner over something you don't own, that's pretty much the definition of theft, or interfering with a security or conversion or something like that. So that's something which is another way of looking at property. And then Hayek sort of had an emergent definition of property. So it's what's efficient, the relationships that everybody forms around a particular thing. Once you have an arrangement where everyone can recognize everybody else's property rights as such, it's kind of tautological in that sense, but it kind of emerges out of nothing. And then once you have something which suits the order that you're trying to work in, then we say that's what property is. It's this relationship and this common normative understanding of who owns what and how we're free to dispose of it. So Bitcoin's interesting in that way because that's exactly how it came about. It's emergent. It's not something that someone said, we're passing a piece of legislation and this is what it means when you go and try to enforce a Bitcoin claim. So the types of property which are kind of, you can go down a list, and there are various categories of property that we would look at. So is it specie or cash, fiat as it's known in the libertarian community? That is something which is very well known to the law as being property and then can be subject to security relationships and other types of things. Is it an account? A depository account at a bank. Sometimes Bitcoin is treated like a bank account balance, but who do you call against? What happens if you can't get your money out? What happens if you lose your keys? What happens then? Those kinds of questions are unanswered. Is it a security or a financial instrument? A lot of people say, well, it's like, the Securities and Exchange Commission is currently wrestling with how to classify cryptocurrencies. And they say, well, some of them are true cryptocurrencies and some are not. A true cryptocurrency, I think, is one where you can't identify someone who has engaged in the relevant series of steps to create something which looks like what's called an investment contract, which we'll talk to in a bit. But if it's not that, and it's not an instrument, and nobody has a right to deliver this thing to you, or no one in the group has any obligation in relation to you, what is the thing? How does it work? We don't know. So then there's this definition, documentary intangible, kind of like a security. I don't think so, because there's no contract. There's a concept called the general intangible, which is in the Uniform Commercial Code, which basically means any intangible property that is property and not otherwise classified. So that might cover it, but that's kind of a cheap cop-out answer. And then there's this new idea, not a new idea, it's actually an old idea. Information is property. So I have some proprietary information which I've somehow obtained or generated, which nobody else knows, a secret, my key. And how do I own that? So if we talk about information as property, which I think is where the law is going to eventually wind up when we're talking about Bitcoin, there are two cases which are really important. One of them in the States is INS, so International News Services Against Associated Press. And that was a case involving the Hearst group and the AP. And what was happening was AP was going around and printing newspapers, and someone from Hearst would go around, read the article, go report it to the INS wire, and then INS would go and republish it themselves, in some cases beating AP's network of newspapers to the press. So basically AP was doing the work, and INS was benefiting from it. So AP sued INS, and they said, this is ridiculous, this is our information, even though it's not, do you have a copyright in something that happens? If a building falls over outside, is there a copyright in reporting the fact that the building fell over? Well, there might be a copyright if you write a publishable work and go register it, and then subsequently someone copy-pastes it. You can say, well, okay, that particular text is a copyright. But what about the fact that the building itself fell over? And so what happened was they developed a tort called the hot news tort, so that the law kind of hacked it. And they said, well, if someone's reporting on something, you have to go and allow them to report on that information, and you have to go and get your own independent sourcing of that data before you can report on it. And so that was a state intervention which basically said someone has a proprietary interest, and if they want to enforce it, they can sue you if you're using their resources and their input to report on this information. In the UK, we're unqualified, specifically England and Wales. There's another case, Oxford versus Moss, or Oxford and Moss, as we would say in England, because it's just you're hanging out in front of the Queen. It's not adversarial. The crown is what matters. So Oxford and Moss concerned a guy named Moss. He was a student at Oxford, and he broke into a faculty lounge and read the exam answers, memorized them, put the paper back, left, and then went and aced his exams. So they went to the director of public prosecutions, and they said, well, he's clearly stolen the information here, so we want him arrested for theft. And this went up, I believe, to the Court of Appeal, and they said, no, that you can't steal raw information. It's not something which is reducible to property. If he took the piece of paper, that would be theft. But because he memorized the information, there's no property interest in that which is enforceable or recognizable by the law. So basically, whatever Bitcoin is, as you can see, my friend Rick Dudley has this on his Facebook profile. I have no idea where he got it. But it is a duck playing the keyboard, a beaver playing the guitar, and a platypus playing the keytar. Bitcoin is a platypus playing the keytar. It's some hybrid instrument which is going to eventually acquire, and probably very quickly acquire, a very specific legal meaning in the jurisdiction in which it works. It's similar, for those of you who know the difference between common law and equity. Common law is things like contracts, statutes, whatever, not common law. Law and equity. Law is something which is directly enforceable in a court. Equitable remedies are things like enforcing trusts, or doing things which ought to be done. Very early equity wasn't well defined and wasn't enforceable in the common law courts. And so initially, the common law lawyers in England at about 1530 said, well, this whole equity thing is a scam, because they're setting up relationships that aren't enforceable in the courts of common law. So what did the English do? They set up the courts of equity. And the courts of equity developed their own axiomatic principles rather than legal principles, which govern how those things function. So I suspect Bitcoin is very quickly going to get lumped into one of these things, where you say, well, the users of the network have some kind of implied contract where, if you have a Genesis block and a decentralized system, there's kind of a tacit agreement that you don't do this and you don't do that. So, and also there's the idea, I'm sorry, I should have mentioned, the relativity of property. I didn't put the cases there, I should have done. I was hurriedly typing this up this morning. So relativity of property is this idea that you have title which is good against someone specific in the rest of the world, but if someone comes along with a better title to it, then maybe they can intervene. So with Bitcoin, we have a really good title register, right? You've got your chain of unspent transaction outputs that are sitting there and saying, well, this guy transferred it to this one, and this one, and this one, and so forth, and you now hold it. And so it's very unlikely that you got that key by some other means. So if someone else then says, well, I have a property interest in that, well, it's like all the fake Satoshis. Show me your keys. If you have the keys, that's very definitive evidence that you are entitled to the balance which lives at that UTXO, and you're entitled to any remedies that arise as a result. So relativity of title is to say, when I get this thing from someone else, I don't know who, let's say fake Toshi sends me 10 Bitcoins, I know that I have good title against anybody who can show that, well, I have good title relative to the rest of the world, unless someone can prove that transfer is somehow subordinate in priority to their own interest over the property. So that's the idea. So it's a hybrid creature. Here we go. It's a hybrid creature, and it's and we haven't got a very neat classification for it. So now on to more specific. Now that we know the sort of general landscape of what we're dealing with, let's talk about some specific issues. So taxes. This is real simple. Pay them. Sorry, it's Bitcoin. There's nothing new about it. Most of the jurisdictions that I've seen have classified Bitcoin as either investment property, which, depending on how you interact with it, could give rise to a capital gain, or income, depending on what you're doing with it. So England, depending on how you're trading it. If you're trading it as a day trader, it's an income receipt. If you're trading it as a long-term hodler, then it's a capital gain. Pay your taxes. The IRS is subpoenaing people. HMRC in England is doing the same thing. So don't cheat that. Next, money laundering. Okay, so taxes. See how easy that was? And by the way, if you have any questions, shoot up, and we can get to them along the way. Or alternatively, we should have some time at the end. So money laundering. What is money laundering? Money laundering is basically taking criminal property or property which has been obtained through criminal conduct and then somehow dealing with it, concealing it, altering it, commingling it with some other asset, and being involved in any way with that property once it enters into your hands. So this is the English definition under Section 387 of the Persons of Crime Act 2002. So basically, you have to have a predicate offense. So if you're legally dealing with, if I have 1 million bitcoins and I just move them back and forth all day long, and there's no crime being committed, I own the bitcoins, I got them legitimately, there's no reason to suspect that that I'm doing anything wrong, then that's not necessarily, or probably not, money laundering. You're just wiring things back and forth between, or wiring or spending things back and forth at different addresses. If, however, let's say there's a securities fraud and you then take some proceeds from the securities fraud, which have been converted into Bitcoin because you bought it at a discount or something like that, then you're starting to step into money laundering land, and that's not good. Because basically in any jurisdiction I can think of, money laundering is an extremely serious felony level offense. So in terms of what professionals would do when we're faced with a money laundering situation, so you can see I've written a whole list, which I'm not going to go through in detail, but this is the list that an English solicitor would have to comply with when you have a suspicious transaction. So if someone comes in and says, hey, there's a $2 million house over here and I'd like to buy it in cash, and I have a big briefcase here with 2 million pounds, and I'm going to go in and we're going to close it. We want to close next week. I don't need to really do any searches of the title. It's all fine. I know what I'm doing here, and so does the seller. That, to a reasonable person, is a transaction which should arouse some suspicion, or to a reasonable solicitor. So what you would do in England is you'd have to go and report it. You'd have to go file a report with the Serious Fraud Office. And so that's the kind of thing. And there's a whole list of stuff. You need to know who you're dealing with, where they got the money, do reasonable diligence on the transaction before you assist in the transaction. And so we have similar rules in the United States. So those are generally the USA Patriot Act, which I know is very popular among the people in this room. See, it's a joke, funny. So the USA Patriot Act imposes similar requirements. There's something called the travel rule you may have heard of, which is that there's a mandatory reporting requirement if you transfer more than $3,000 in a single transaction. If there's a suspicious transaction over $2,000 in size, there's a mandatory reporting obligation on a money transmitter who's dealing with those. And it bears mentioning, most of the Bitcoin businesses you will be dealing with as either an entrepreneur or anybody else. Coinbase, they're all money transmitters. They have money transmission licenses. So those are the, yes?
What's the travel rule? Can you explain that?
So the travel rule, yes. The question is, what is the travel rule? The travel rule is, if you have a transaction between two persons that is $3,000 or more, there's a reporting obligation, well, not a reporting obligation. You have to you have to record the transaction for future use. I don't believe you have to report it automatically, but you have to also obtain very specific information about the sender and the recipient, which is then contained on your files, which can be audited at a later date. So if you have two persons who are wiring money back and forth to one another, and you don't know who the other party is, so you're a bank, and you wire it to someone else, and you don't have any identification on the recipient, then you're in violation of that rule. So with Bitcoin, similarly, if you have a Bitcoin business that is licensed as a money transmitter, and then you have party A and party B, party A sends money to party B, and you don't know who's on both sides of that transaction, and you're sending in Bitcoin, which is money or money's worth, you could have a money laundering issue, conceivably. There are lawyers who specialize in this. I'm not one of them, but that's something that, if you're setting up a Bitcoin business, you definitely want to be aware of, particularly as you need to be aware of whether you're a money transmitter as well, because you're sending and receiving large amounts of cash. Similarly, you have a requirement. If you send more than $10,000 in a single day to a single person, you have to file a report with the IRS automatic computer office in Detroit. It's called a CTR, so a currency transaction report. And this is all very boring, so I'm not going to really dwell on it. So, right, but of course, Bitcoin, nobody cares, right? So here we see a typical transaction. It was an exchange. Allegedly an exchange, or supposed to be an exchange, they send $150 million like that, because that's what you can do with Bitcoin. You can send vast quantities of money instantaneously anywhere in the world. But there's not a whole lot of reporting which goes along with these transactions. And there's certainly not something like the travel rule, because we identify our users by their public keys, not by personally identifiable information. So there's very clearly a compliance gap, which is occurring. I'm not making any statements here. I am a libertarian, right? So I'm just telling you how it is. I'm not saying this is the way it should be. But what I am saying is if you're going to start a business in this space, you need to be aware that this is the way it is, and you want to stay on the right side of the law, not because we agree with this, or not because we don't think it's a little oppressive and it's too much surveillance, but because we want to avoid going to prison or getting sued. So YOLO, two examples of where this happened. The first, really the first major Bitcoin AML prosecution was Charlie Shrem, who I'm sure a lot of people know. The facts of that story were Charlie ran a company called BitInstant, which transferred USD into Bitcoin instantaneously with very little KYC. And there was a chap named Robert Vela who was transacting on the Silk Road. Basically, Vela was held to be engaged in unlawful money transmission for his business in facilitating transactions on the Silk Road. And then Charlie was held for was held liable for aiding and abetting that. He got 2 years in jail. So that was the first, and really there was a huge gap between what happened then was a lot of the companies that were involved in Bitcoin then started ramping up their compliance procedures. So we didn't see a whole lot more enforcement after that occurred. The second case study, this is actually more recent, is a chap named Jason Klein. And he was just doing some, normal Bitcoin trading, selling $15,000 here and there for USD on local Bitcoins. And he was doing so, unfortunately, with federal agents. That's never a good thing if you're trading things with federal agents. So what happened there is they charged him with operating an unlicensed money transmission business, because you have to be registered as an MSB if you're going to be engaging in currency transactions. And so as a consequence of that, I believe he pled guilty. And Wade was right, pled guilty, and I'm not sure what the sentence was, but it's certainly not good. And the third one is BTCE. So BTCE is a Russian exchange which was taken down earlier this year. I can't remember exactly when. I think it was this summer. And so the operator was living in hiding in Greece, and if you think the long arm of federal law cannot find you, it can. And so he was arrested, and he's currently awaiting extradition to the United States. That operation, of course, is fairly substantial when compared to your nickel and dime local Bitcoins operator, but I think that shows the range of potential interventions that you can see from a regulatory authority or law enforcement authority. So lending, security interests, and other financial. Any questions on 1-1 or 2? Cool. No? Yep.
One of the things about money laundering, what you were saying, is that you have to be able to tell that it wasn't involved in criminal activity. That would involve a title search. So how do you go back through blockchain and say, well, none of these were ever involved in illegal activity?
So the question was, good question. The question was, how do you guarantee that the money you have is not involved in illegal activity? Do you have to go all the way back into blockchain and verify that it's not subject to some kind of lien or other interest or flag from somebody that this is a fraudulent transaction or somehow was involved in a crime? The answer is you can't really do it, but the obligation nonetheless exists. So it's possible that you could receive a Bitcoin which is subject to some type of other interest. It could be a security interest, it could be that it's been flagged or blacklisted as the proceeds of crime. And once that happens, there are methods where you can put the world on constructive notice. So if you have a lien, you can determine who owes the obligation. You go file it, whatever the appropriate register is in whatever country you live in. And that could conceivably mean that you're not a bona fide purchaser for value when you receive it, because you had noticed that somebody else had the interest and now you're interfering with that. So that's a real concern. We haven't really seen a lot of it, and I think the reason, we haven't seen that crop up often, and the reason for that, I suspect, is because a lot of Bitcoin transactions, people would really rather not see them inside of a courtroom, because there's a lot of stuff people don't want to own up to. So it may happen in the future as it becomes more mainstream, and then we'll have other methods of, asset freezes are something which happens in this space. So if you have a court order which says these assets are frozen, you can identify a specific public or private, public key pair, then maybe you have a means to go and get damages or specific performance or something else. But that's something which is very nascent, it's a problem, you just don't see it crop up very often in my experience. So lending, security interests, and other financial transactions. So being our own bank, right? We're going to go, we're going to unearth, upend the world financial system. How are we going to do that? Well, we're going to do it by replacing the banks, or by being more efficient than the banks. And Bitcoin has some weaknesses in that regard. It is peer-to-peer cash. That does not mean it is a peer-to-peer account. It does not mean it's a peer-to-peer fractional reserve. Every transaction that you engage in, so we read the white paper, it was designed to replace trust with cryptographic proof, right? So you do that by knowing that when the transaction completes, you have 100% of the transaction in your bank. Usual banking, normal banking, is that you have an obligation. You then assess the performance of the obligation against the credit of the person who is providing or who's getting it and saying, well, I'm going to issue a bond that's worth $10 million that pays 3% interest over the next 30 years, and if it's HSBC that's doing it, or Germany, or the United States, then you can reasonably rely and treat it as a cash substitute. But the cash isn't there. It's very efficient from a capital perspective, because you just hand out the promise, and then you just kind of have to wait, and all you have to do is make sure you have the cash flows to satisfy that promise. Bitcoin doesn't work like that. You either have the Bitcoin or you don't. And so as a consequence, it's kind of difficult to do mainstream financial transactions with that. And so the only means really to effectively secure it, if you're looking to do higher order transactions on top of it, is by possessing it. So as a consequence, if I want to lend someone $1 million against their Bitcoin holdings, it probably means that I have to go and take the Bitcoin and move it into my own accounts, at my own address that I control. And then when they're done, I'll have to release it back to them. So you're introducing a whole lot of trust and a whole lot of discretion into something which is customarily not supposed to be discretionary. So it's kind of an ass-backwards way of using this stuff. So, next slide. One thing you can do, which is kind of interesting, is you can leverage long. So the cryptocurrencies allow you to borrow and go long. Basically, so there's a concept called the stable coin, which you may come across here and there. And basically what it is you take a bunch of cryptocurrency, you lock it up in a smart contract. So let's say I've got 1,000 Ether, right? And I want to go long another 100 Ether and get some exposure. What I can do is I can take 300 Ether and lock it up in a smart contract. I can create the stable coin, which is another 100 Ether, let's say, and equivalent value. And I can go create that. It's backed by the collateral I've just deposited, and then I can go sell it to somebody for 100 Ether. So all of a sudden I now have exposure. My total portfolio is 1,100. I've gone long. And so people are saying, well, this is great. I can go get exposure more Ether, or I can go substitute and go buy a car and still hold my Ether holdings. So then I can, when the market goes up, I'll get all of the benefits. The problem with that, of course, is that if the market goes down, your entire collateral pool gets dinged, not just the amount that you've reserved and set aside. So on the upside, you get one-to-one returns. On the downside, it hits you 3 times as quickly if you're 300% collateralized. So there are multiple schemes which allow you to do this. They're questionably legal. BitShares is one which did not work out particularly well. MakerDAO is now the hot new thing, and there's one called Basecoin, which Andreessen Horowitz and Bain Capital Ventures invested in. And if you type in Basecoin in Google, my blog post saying it's garbage, it's third from the top. So if you're interested in looking into that, I would recommend you do so. And when someone comes in and says it's magic and it's going to save the world and fix all your problems, it's just a repackaged exposure to the underlying cryptocurrency. So you can go long, but if you wind up getting the short end of the stick, it's not going to work out well for you. So in the usual course, when you give other people your money or your securities, there are arrangements that are set up by law which allow you to keep those things out of the bankruptcy estate of the person you've just given it to. So if you have securities which you're clearing in Europe, for example, and let's say Clearstream, which is the economic depository, goes bankrupt, your securities will not form part of Clearstream's bankruptcy estate, so you will be able to get your securities back in full. This is clearly not the case if we look at something like MT-GOX, and that can result in some very unfair consequences. So MT-GOX, everybody knows it and knows the story, but it turns out, as it says, irony of ironies, Mark Karpeles could actually make a lot of money from it because the losses were denominated in dollars by the bankruptcy trustee, and Bitcoin was $600 a coin at the time that MT-GOX went bankrupt. So as a consequence, the creditors in bankruptcy are entitled to $600 a Bitcoin. However, Karpeles holds Bitcoin, which is now worth $10,000 a coin. So as you can see, that's not the kind of thing which would happen with a Clearstream. And you can do this with a Bitcoin as long as you know that the Bitcoins are being held by an entity which is insolvency remote. It's just that right now we don't have institutions that are sophisticated enough to that either have the staff or the licenses to actually go and become a proper custodian. It's been too easy just to do it on the back of an envelope. Another case study here we have is, so another thing to look out for is when someone says, we have a decentralized bank. This one's called a Rise Bank, and I knew it was garbage when I looked at it. As you can see, Evander Holyfield was the sponsor, because when you think about banking, the first thing that comes to mind to me is, I'm going to fight to win against Mike Tyson. That's what I think. But anyway, a Rise Bank, and so I looked at it, and I ran a software company, right? And they had this list of like 50 different APIs that they developed, and there were like 2 people who worked there. And it was like, that's codswallop, that's twaddle. Because it takes a lot of work to develop an API. Apparently, the Securities and Exchange Commission in Fort Worth, Texas, thought so as well. And so they obtained a preliminary injunction seizing all of their assets and appointing a receiver. So be careful when someone says, well, we've got a cryptocurrency denominated bank here, we've done da-da-da-da-da. As we can see, it's not so easy to actually set up a proper financial transaction. And as a consequence, when some rando dev decides, oh, well, I've got a new da-da-da, don't buy it, because it's really super complicated. Ask who their auditors are, ask who their law firm is, look and see who's backing them. This is complicated stuff, and so a slick website's very easy to create, but a proper bank is very difficult to create. And then there's Mulan.io. This was sort of a really, really early 2014, similar to a Rise Bank, just a straight-up fraud, where it was an exit scam. So again, very slick website, Dogecoin-based exit scam. We've ruined Dogecoin for years, but it's back now, which is great. So this is just another example if you choose to look it up. So now, initial coin offerings. This is what everyone wants to hear about. Just don't is my personal view on ICOs. So this is what we're dealing with, right? So you go to some of the ethereal summits in San Francisco or New York, and you got people running around, and they made millions of dollars, and they're taking their pants off in front of rooms. Really, seriously, go ethereal in New York last June. Some guy wore an I Heart New York boxer shorts and an I Heart New York t-shirt under a suit. And then like, oh my God, I'm transformative. I'm the stiff like city guy, but now I'm wearing boxers with hearts on them because Ethereum is so wonderful and I'm so rich. And so that, okay, great. I mean, you might be really happy that he's made millions of dollars overnight, but I look at that and I say, do I really trust that man's opinion? And Josh, is this really, the kind of prudent thinking that we want to be doing in relation to cryptocurrencies? So the problem space is this. This is what we're dealing with. This is ICOs. This is crypto today. It's nuts. And as a consequence, people have raised stupid amounts of money in the last 12 months. Elizabeth Warren, Elizabeth Warren, but anyway, she had a good question of Jake Layton before the Senate. She asked him, how much have these projects raised in ICO money in the last 12 months? He said, $4 billion. She said, how many of those have registered with the SEC? He said, not one. She said, how many upcoming projects have registered with the SEC? He said, not one. She said, so you're saying this is against the law? He said, yes, it is. So all of this is against the law. Most of what we've seen in crypto is regarded by well-regarded lawyers and conservative lawyers. And you want your lawyer to be conservative. You do not want them to fly by the seat of their pants. Most of this is regarded as illegal. And so there just hasn't been a whole lot of enforcement, which has happened at the same time, so people just keep doing it. So the justification for that is that, we call it elevating form over substance. So if you have depending on what country you're in, when something becomes an investment, when someone gives you money, or when you give money to someone in exchange for something, they give you something back, which you're supposed to make a profit from, generally speaking, that's an investment. So it doesn't matter what you call it, it doesn't matter what it is. It doesn't matter if you call it a utility token, it doesn't matter if you have an associated software application which goes with it. If it meets the relevant hallmarks or it's on the relevant list, then it's an investment and it's going to fall within the relevant regime. So Filecoin is one, and it's actually probably Filecoin's probably the most legit of the ICOs that I've seen. One that runs, and that's kind of why I picked it for this example. If there's any coin that isn't going to be a security, it's that one. Because basically people are buying it, there's an application which goes along with it called IPFS, which I have myself used and my company used, and they want to develop it into something which is kind of like a replacement to BitTorrent. So the argument goes, we're not selling a security, we're selling an access token to this. And so but then of course below, there's that word, invest. And that's build a diverse portfolio of pre-launch token investments. So as a lawyer, you look at that and go, my God, what the hell are they thinking? But in terms of projects in the space, that's closest to legit. You then see others which are not, and so it's like, well, buy this and you're going to get rich. And maybe we'll have some ancillary software application which is attached to it. That I think would very clearly be a security, but depends again on the facts of the case and which jurisdiction we're operating in. So in terms of elevating form over substance, my spirit animal is a marmot. And so I found a case involving beavers. So as you can see, here's a mama beaver and a little adorable baby beaver. And so SEC against the Weaver Beaver Association was a case where the Securities and Exchange Commission, basically there was a beaver farm out in Colorado. And instead of selling shares in the beaver farm, they would say, we are going to take some beavers for you. We're going to bring them down from Canada. And for $3,000, we will raise the, because like beaver fur is going to be the next big thing, right? You get hats, people are going to be wearing coats out of it, it's going to be super. And so what we'll do is we'll raise the beaver for you, and if you don't want to do it yourself, you can have the beaver on your own. but for $125 a year, this isn't like 1970s, that's a lot of money. We will raise the beaver, we'll have little beaver kits, you'll have a little beaver farm, you'll have this little pack of beaver that will grow and reproduce and very happily make you fantastically rich when you sell them very cruelly to be made for cards. So the SEC looked at this and said, well, I mean, it's quite obvious that this is an investment contract. These little critters, because nobody, what are you going to do? Take the beaver home, put it in your bathtub? I mean, nobody is actually able to do this. So what we looked at is the hallmarks of whether it's security, there's the efforts of others, leg of this, which is one leg is that it has to be as a result of the efforts of others. So if you do something on your own and it makes you rich, that's not a security. But if you do something in someone else, or if you invest in something and someone else is doing all the work, then that is one of the elements that's required in order for it to be security. So as a consequence, this scheme with the little adorable beavers was held to be a security. And so that's, the SEC said this is clearly not what it says. There we go. So anyway, deeply problematic. Deeply problematic. If someone's saying, give me your money and you're going to make money back, that should set off red flags for you and be further, it should be a jumping off point for further inquiry as to their registrations and the legality of what they're doing. So case studies. Tezos, really sad story here. They raised a ton of money, like 240 million in Bitcoin last May, which means it's probably closer to $1 billion plus now. And basically they had a fight internally. Whoever was running their Swiss foundation decided that he would rather be in control rather than the developers. And so as a consequence, they're now all getting sued, they're suing each other. And their token holders are suing to get their money back, which they put into it because it's appreciated 5-10x since they've invested. So that's the kind of thing that happens. This is in Switzerland and the US. The lawsuits are flying right, left, and center. Being based in Switzerland and having a foundation in Zug is not going to save you if someone wants to sue you. Federal courts have jurisdiction over you, even if you're abroad, as long as the activity is happening in the United States. Similarly in the UK, it depends on where you are, but don't think because you've moved to a friendly jurisdiction, that's somehow carte blanche to allow you to go and operate in every other country in the world. Every jurisdiction has different laws. In the United States, we have 51 different jurisdictions. In Britain, they have 3. In Europe, they have 28. So this is not, although they do have a single passport, which allows you to move around, you have to comply in every single one that you're operating in. So what works in the US and England might not work in Japan. Another case study, this is genius at work. This happened in Connecticut. Kind of Josh Garza set up these mining contracts where you pay someone money, you say, well, here's $4,000 and you're going to pay me a fixed return of $100 a month. That was a Ponzi scheme. And he also had a coin which he said was going to hold a price floor of $20 per coin, which basically meant he was willing, so the ICO raised a bunch of money and said, there's a price floor, I'm going to support this price of $20 a coin. It didn't support that price, so he wound up pleading guilty to fraud and is awaiting sentencing now. So that was in the District of Connecticut. So that's pretty much the view from 30,000 feet. I would now be very happy to take any questions you might have, subject to the proviso that it isn't legal advice. Ben?
So, the defense fund that is receiving crypto donations, is the defense fund obligated to vet these people to see where it's coming from?
Yeah, I would think.
LLC.
I mean, I think I'll answer it for England and Wales, not for the U.S. because it's a really specific question.
And how do you, I mean, like you're saying, it's not.
KYC. So you have to have people give their names. That's one of those. Because the defense fund is really specific. That's a very specific rather than general question. I'm going to say you should talk to an attorney about it, but that's a risk that certainly needs to be considered. So, yeah.
I own a business in the service industry. We take cash, check, credit card, etc. Our average ticket is around $5,000. If I was to take cryptocurrency for payments, is that something that would be over that threshold that it would have to be recorded?
I would talk to a lawyer. Yeah. So if you're asking specific questions about your businesses, I'm just going to tell you to talk to a lawyer because I'm not yet licensed in the U.S., so I'm not engaging in the unauthorized practice of law. So I'll be happy to give very general queries, but if I say you should talk to a lawyer, that generally means go talk to a lawyer. If you've heard it up here in the general and you think you might have an issue as a consequence, and the purpose of this talk is to say, go talk to lawyers. Don't be afraid of them. It might cost you 4, 5, 10 grand to get something set up, but that will save you enormous amounts of headache and pain and cash down the road because you've started. I've seen every one of these cases that we've gone through today. The takeaway point here is that someone didn't do their diligence in the beginning. And they thought that we're going to get away with it. There are a lot of ICO promoters who are not doing their diligence today. They think they are going to get away with it. They're not. They're not. We think it looks like they are. They're making tons of money. I really highly suspect that the regulators in various different jurisdictions are not going to sit back on the sidelines and just allow this. To the extent they continue to allow it to grow, it grows and grows and grows until eventually it becomes too big to ignore. So really, if there's something up there which pushed one of your buttons, go talk to an attorney, like Monday. That would be my advice. Yeah.
So you talked a little bit about tainted title on currency that involved in previous illegal activity. Can you foresee ever a court attempting to issue a court order for a hard fork and a rollback and the havoc that might cause?
Great question. Really interesting question, actually. Yes, I can. So the question is, yeah, you have a mic, so I don't need to repeat it in the video. So, could a court order a rollback? It depends of the chain. So what I would say is that the answer to that question will depend on the circumstances of the theft or whatever the misappropriation is of the funds. Who could be potentially in charge of the blockchain? So there are some projects where it's very clear that there are a couple of it's a small group of people who are in control and have the ability to push a hard fork onto the chain. There you then have to ask yourself, what is the relationship between the developers of the chain and the users of the chain? And this is yet to be decided, and I think that's actually it's a good question because it's the most interesting question of everything in blockchain. What is the relationship between among the users of the chain rather than between? And who owes who what? So if you're one of 5 guys who manages, I don't know, CoinChain Limited, whatever, and you administer this chain and there's a huge amount of theft, do you have some kind of trustee arrangement? Do you have a fiduciary obligation, as the early trustees did in the law of equity back in the 1500s? Do you have that obligation to then make rights and make whole the beneficiary of the thing that you're administering? So in England and Wales, England and Wales is interesting because the ICO laws are different, securities laws are different. So you kind of do a different decision tree, and if it's not on this list of stuff, then you hop over to another decision tree. Whereas in the US, they have this kind of funky, if it looks like a duck, it's a duck and it's a security. So in England, you go down this decision tree, it's not on it, and then you go to this thing called unregistered collective investment scheme, which is like just the mushiest definition you've ever seen. And the goal is to not be one of those. And if you're not one of those, then the question is, what is it? So you go down the list, tick, 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 and it's not anything else, and you finally arrive at this question, what have we got? And it kind of looks like a trust, but no one said it's a trust, and nobody has created a contract which constitutes one. So yeah, really good question. We don't know the answer. I think it will probably have to be hammered out by a court, and I think we'll probably know the answer at some point in the next 10 years.
So I'm going to kind of make an argument absurdum here, but Wikipedia, the article's named Contaminated Currency. Most banknotes have traces of cocaine on them. This has been confirmed by studies done in several countries. In 1994, the blah, 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 U.S. appeals determined Los Angeles, out of every 4 banknotes on average, more than 3 are tainted by cocaine or another illicit drug. So I would like to go for asset forfeiture here, and I'll be doing the collections for the government. All your cash has been tainted in the blockchain of cash, and please submit to your government. No, I don't understand how you're supposed to do this title research that limits it. It's asinine from a common sense and legal perspective.
That would likely be a violation of someone's due process rights. In the United Kingdom, they would call it an unreasonable exercise of prosecutorial discretion, which abrogates people's right to property and ownership. So in the U.S., if you have a dollar bill with trace cocaine on it, and you went and said, well, we're now going to do blanket enforcement, firstly, how did you find out that it had the cocaine on it, right? So did you search my dollar bill? Well, did you have a warrant? Did you have probable cause? Did you have reasonable suspicion? Did you have anything? So there, the answer would be that you could, I get his argument to my absurdum, but the answer there is, well, it's a due process violation. In Britain, similar due process violation under the Human Rights Act. In terms of the blockchain, the difference is really notice and the public nature of it. So there are mechanisms by which you can go and create notice which binds the rest of the world. So when you're doing security interests, that's most common. So you go and file a floating charge, register a floating charge at company's house in Cardiff. And you put everybody else in England, or anyone dealing with an English company, on notice that there is a charge over all the assets and undertaking of that company. If that includes some bitcoins, then you go and say, well, these unspent transaction outputs we also charge. And so then, if you then transfer it to a transferee in Britain, and then you just say, well, this is an unauthorized transaction, breach of our security rights, you had notice of it because you should have known when you received it that it was encumbered by this charge. So that's the kind of, it was a good question. Yeah, go ahead. Then we got two more.
One more thing, in my research of Charlie Shrem's case is he knew that the money was tainted, and I think that's mainly the difference, whether you know or you don't know.
Oh, I wouldn't want to go. Go ahead. Come on.
So what about cryptos that are not meant for general circulation? You're not like a Bitcoin or a Litecoin. They're meant to be for general commerce. We have something that's very narrowly focused, or it's in a closed marketplace.
Good question.
Or it's not necessarily meant to be money, as a layman understand it. Is there a different set of criteria, or less or more legal questions about that?
Yeah, I mean, facts and circumstances is the answer. Depending on what you do, so you have so depending on how to put it, depends on what it's being used for and what the legal rights are around it. So if you have a specific cryptocurrency which is designed to operate in a specific market, the kind of stuff you want to explore is whether this is an air mile or a coupon, in which case you might say, again, England, rather than US, they have a category of stuff called electronic money, and so it might be e-money. And there's a series of regulations which govern how that works. So you could say we have this closed walled garden ecosystem where this cryptocurrency, there was called Ven. So it was a guy who works with WEF, I can't remember what it was called. Ven was a cryptocurrency designed to be used in a bunch of co-working spaces around the world, and it would get you access and whatever else you bought into it. And that was back in 2013, 2012. So I don't think it went anywhere, but those ideas are certainly there. What we find is that that doesn't tend to have the viral nature of cryptocurrencies, so we don't see as many of them. Equally, you could just have a cryptocurrency which falls into something else. It's a security. It's a company called Gab.ai. I'm sure a lot of you know who that is. That's sort of Twitter for those with a slightly more conservative bias. And they have done my understanding is they're doing a securities issuance which is tokenized on a blockchain, but it's basically B shares through something called Regulation A+. So they're again creating a token. It's going to be traded as money or money's worth, but what it actually is some equity in the underlying company that's been then transmogrified into token form. So there's it depends on what you're trying to do, what the use case is. Then we're done, I think. We got plenty of time. Go ahead.
Is there presently a ledger or a public notification where someone can go out and say that this is tainted Bitcoin, Litecoin, Dashcoin, Ethereum coin, whatever coin, you said there's a risk of taking it. How do I go and screen? And if not, shouldn't there be one?
Yeah, there should. There isn't.
And is there?
There isn't, to my knowledge. There are a couple companies. What the heck were they called? So there's a company. It's now turned into Big Chain DB. They're based out of Brooklyn. Great bunch of guys. Really interesting tech. And they originally started out as an IP register on blockchain. So the idea was you could go and post your copyright onto this chain, which would then take the image, would hash the image into it, and then you could reference it at a later date. Ultimately, what you need for something like that to work is you need the protection of a state agency, the prototypical men with guns, to go around, and you need enforceable rights. So at the moment, we don't have that. And we're not, when we haven't sorted out what the nature of the problem, we'll get through that and we can talk afterwards. Yeah, go for it.
So part of the process you described is the registering of I have and I'm asserting a claim against this thing.
Yeah.
So, but there has to be some declaration of a claim,
Yep.
which in the United States might be published in 3 newspapers. Like there's a whole bunch of different.
I mean, so if we're calling it a documentary intangible or something, you would publish it you would file it with the Secretary of the State in the state where the person who owns the asset, if it's you, then file it, by all means. But it would basically be the Secretary of State in the state, unless it's a federal thing, in which case there are different registers. In England, similarly, there are a whole bunch of different registers where you can file security interests. But at the moment, with blockchain stuff, there's no one's really said, okay, if you have a bunch of bitcoins which you think are stolen, which belong to you, go file your claim here, and we'll encumber them, and we'll try to track them down. It doesn't exist. So,
Thank you.
So we're currently in a state with blockchain where there's a manifest experience where you can pseudonymously, put money into accounts and move it between accounts that would basically be clearly illegal for any individual company to provide it, right? Like JP Morgan would be happy to provide anonymous cash bank accounts and move between them, but they can't do it. Do you think that the United States would need to pass additional laws to crack down on Bitcoin, or could they interpret existing laws, such as confirming a block as a violation of money transmitter regulations, or things like that? Do you think that existing law can be used, or there need to be new laws?
It's interesting. So Jake Layton, who's the chairman of the SEC, he was asked that very question last week in the Senate Banking Committee. And so there were kind of two answers that he gave. The first one was, yes, we have the enforcement capability now to crack down on what's necessary now. But equally, he said there may be a requirement. It was a very lawyerly answer. It was like, well, we have the powers now. We're not asking you to pass any new legislation. The mighty Senate, we would not do that because we're capable of doing our jobs. But he said there may be a requirement for harmonization. And so that's just a question of how to put it. Sorry, the gerbil's running on the wheel. so yeah, it depends on what issues arise. So at the moment, I think the CFTC is mostly concerned with what's happening in the Bitcoin futures markets that they're trading in, the futures contracts that they're trading in Chicago. The SEC, I think, is more concerned with investor protection. Then you have FinCEN, and they're more focused on money transmission issues. Then in Britain and Europe, the regulators have their heads up their proverbials. They don't. I mean, the FCA has not. They barely enforce anything as it is. Well, they do some enforcement, but not seriously, and they've kind of disclaimed responsibility for stepping into the Bitcoin space. Part of that is that Europe traditionally follows the U.S. from a regulatory perspective, so they can then arbitrage, which they did with something called Eurobonds back in the 90s. And so that's one thing that we're waiting to see what the Americans do and see how the tech evolves, so they can then say, well, we're going to position ourselves here so that the Americans might crack down, but we'll get all the new business, particularly in Britain with Brexit. I think that's become a priority for them. So the answer is who knows? The answer is a very, very emphatic maybe.
Thank you.
So this isn't really a specific question, but I was wondering if you could touch on sort of how you see GDPR coming into play with this space.
Yeah, interesting. So GDPR, questions about GDPR, which is the Global Data Protection Regulation in Europe, which basically imposes all manner of disclosure requirements. I admit I need to be more familiar with it than I am, but this year I'm spending my time focusing on learning American law, so I'm kind of behind the times in Europe. But basically it's all kinds of stuff about managing data and the right to be forgotten and all issues like that. And of course there is no right to be forgotten on the blockchain. And so the question is, how do you go and enforce a right to be forgotten when you can't take it out of the chain without breaking it? And then who do you sue, and what are the liabilities if you do so? So that's an interesting question, one which undoubtedly will see litigation in the European Union, and we'll probably see people winning, at least in the short term. But all really interesting, and watch this space. It's going to be really fun to watch how the law wraps itself around all this new technology that the people in this room are using. Thank you. We got one more. Oh, no. I saw you get up. So
I don't know if this is a quick one or not, but we talk a lot about regulations that are needed to protect investors and consumers and people and fight against crime and stuff like that. Can you maybe just talk a little bit about whether you think we need all that regulation? And also, isn't the prospect of coming DAOs, decentralized autonomous organizations, going to potentially end run around any ability for a government to be able to regulate any of that by not making a there that they can go after?
Cool. So a DAO, for those of you who don't know, is something called a decentralized autonomous organization. And it was a very common idea in the Ethereum cryptocurrency community. And there were sort of two competing approaches. The first approach, which actually gave birth to my company, was that you can use a DAO and then drop it into a legal structure and build and automate most of the functions of that legal structure with smart contract code. And so that became the permissioned blockchain universe, the hyperledgers, all sprung out from that. The other idea of the DAO was that you have something which operates with cryptocurrency and can automate relationships without anybody sitting in the center in charge, like a trustee or a custodian or a bondholder representative or whatever. So we had a very famous example of a DAO, the first DAO allegedly, although we built ours first a year before. in 2015, which basically was a guy named Stefan Toole and a bunch of the Ethereum sort of set. And they said, we're going to go raise $150 million in Ether, put it into the structure, and then it's going to become a decentralized venture fund, and we don't need venture capitalists anymore. Great. Well, so they set it up, they put the funds in, and how it's supposed to work was you put the funds in, the funds then get distributed by the company, by the DAO to projects that are voted on by the members of the DAO in proportional to how many shares they have or how much DAO token they bought. That then gets given to another company. The company then issues what are called reward tokens of their own, because that's what Ethereum is about, tokens within tokens, and tokens all the way down. And it's just, I really don't like tokens. So anyway, and then magically, because all these companies are using the DAO for this, the value of the tokens was supposed to capitalize back up into the DAO tokens, which were ultimately purchased, and then you could go sell them on the market. So it'd be like a distributed venture fund. Of course, there was no way for this to actually happen because there was no relationship between the reward tokens on one hand and the DAO tokens on the other. We were just supposed to assume that the ecosystem would become more valuable because people were using it. There's no way to actually extract the value as you would with a legal relationship and say, we've got a contract, I give you money, I own this, you liquidate. When you liquidate, there's a funds flow, it goes to these people in this order. So, and if you don't do it, I will get a judge to give a court order and throw you in jail, or I'll get damages. So that's the usual way of doing it, is you have a connection between each step. When you remove all the humans from the equation, you have to be really careful, because if you miss a step, then what happens is you have something which looks like the real thing, but isn't the real thing. It doesn't function like the real thing. So DAOs are very, very preliminary, I think, is the answer to that question. And they need a lot of work, and you probably need to do some legal structuring as well to ensure that whatever is being created on one end can be returned as value to the people who are doing the investment on the other. And right now we haven't seen a whole lot of that. It's just, you can do that if you assume that the value of everything is just going up because crypto, people are getting rich doing that and following that approach. In the long term, that's not sustainable as people kind of just dust off the surface and look under and see that none of the necessary machinery is there. In terms of regulation generally, do we need more? I fear that we're going to have more, whether we want it or not, or whether we need it or not. I think that the regulators, people are cutting corners right, left, and center. People are not. If you're issuing a crypto token, you can probably do it legally. If you register the token with an ICO, you can probably do it legally. If you're going through this, the relevant authorities in your jurisdiction, you only issue it to people who are allowed to have it issued in that jurisdiction, and you list it like any other investment. Or in the alternative, if you structure the deal and you say, well, this is actually just a coupon, it's redeemable at par for a very specific service, or we have a pile of dollars sitting in a bank account, physical dollars, which are redeemable one for something. Go hire a lawyer. Those are transactions you can structure. With what we're seeing now is just what we're going to create a new cryptocurrency. It's going to go to the moon because Lambo, and isn't it going to be great? We're all going to be rich. That's deeply troubling from, I think, an ethical perspective. We shouldn't be, as libertarians, we should not be supportive of that, because it's, when we talk about freedom in the market to do certain things, I think at the center of that has to be that there has to be some standards for fair dealing for those who need fair dealing rules to protect them. Because if we don't have that, what's going to really very quickly happen is people who are getting screwed are not going to buy into the fair dealing system anymore. So we have to impose these standards and norms. At the moment, the way you do that is by ensuring that the regulators regulate contracts which are exploitative. It's possible to have contracts that people enter into that they don't understand, that are unconscionable. That's something which has been around for a really long time, and I think we do ourselves in the movement a disservice if we don't understand that, at least for that bare minimum, ensuring that there's a fair basis for everybody to contract on. If we can't do that, then there's no point in having contracts at all. Great, thank you.